All right, so we've been speaking with experienced attorneys from across South Carolina as we prepare to cover the big retrial hearing for Alex Murdaugh, the convicted killer, scion of one of the most powerful legal dynasties in South Carolina, convicted of murder back in Walterboro, South Carolina last spring. Now those verdicts in peril. A big hearing is being scheduled for this month in Columbia, South Carolina, the Richland County Courthouse. Former South Carolina Chief Justice Jean Toal will be presiding over the hearing, which will determine whether Alex Murdaugh gets a new trial. We are joined today by an attorney from the upstate, but you've got some Walterboro connections, if I'm not mistaken. Am I right? Bill Young from Greenville, South Carolina, but you've got some connections to the Low Country.
Yeah. Hey, Will, it's good to see you. Thanks for having me on. Even though I live in Greenville now and have lived there for the past 10 years, I actually grew up in Walterboro, spent 18 years there. So it was quite something to see my hometown and our little courthouse plastered all over the news.
And your dad?
My dad is fake John Grisham.
That's right.
Also the mayor of Walterboro. He was the one who was misidentified during
Was
the
your
trial.
phone blowing up that day?
So it was. I think I was in a mediation that day, and so I had my phone on Do Not Disturb, and I looked down, 3 or 4 o'clock in the afternoon, and I see I've got all these messages, and I'm just, I think somebody's died. Like, what in the world? And it is just person after person just laughing at this. And then my sister sends us a link from, I think, one of the newspapers in Europe that had a picture and a story. I mean, nothing else encapsulates the kind of absurdity of everything that's going on.
Let me just say this, as somebody who spent those 6 weeks in Walterboro, been back several times since the trial, what an amazing job that town did. For an international spectacle like that, everything was just handled flawlessly, at least outside the courtroom. We're going to talk now a little bit about what may have transpired within the court. But let me ask you this. Before we get started on this, I want to pay you a compliment. You're a guy, background personal injury law, but your knowledge of these cases, in fact, we joke in the office that if Bill Young's tweeted you or retweeted you, you messed something up, because you are the fact checker on this stuff. And I got to say, I get a little, I clench a little bit if I see you on my feed, because I'm like, oh man, what did I mess up now? But you've been following this for a while. You got an eye for detail. Let me just start with a bottom line question. Where are you right now percentage-wise on Alex Murdaugh getting a new trial at the end of this process?
We're still waiting on a lot of information, I think. The defense filing this morning still laments not having all of the information from the state. At this point, I don't know. I don't know what Chief Justice Toal is going to do. What I've tried to do is I've tried to prognosticate based on what she has written in the past and prior decisions that she's been involved with, as well as the Supreme Court opinions relating to this. Unfortunately, there's really not that much out there. Chief Justice Toal went on the bench, was on the Supreme Court starting in, I think, 1988. She was there for 27 years. And I'm not going to swear that I did a completely thorough review of all of the cases before the Supreme Court in that time, but I only found a couple of opinions involving jury tampering in which Chief Justice Toal was involved. So we really don't have a lot to go on as far as what she thinks is important, or how she sees the law, or even what the law is concerning this level of allegation.
Well, let's talk a little bit about Justice Toal for a minute, and I want to ask you this question before we get into kind of the specifics of what's going to be argued and the witnesses and all that. You know as well as I do that there are pressures that bear on our justice system outside of the facts and evidence and precedent. For example, there are concerns that a Murdaugh retrial would be a black eye on South Carolina's justice system. Not that I would argue we haven't had a few of those in recent years, but that argument's out there. But then there's also the argument that if the verdict is allowed to stand, that some of the admissibility rulings that Judge Clifton Newman made during the trial could create problems for the system moving forward. So there's some arguments to be made that there are pressures coming from both sides. If there's something to fix here, and if Justice Toal needs to fix it, which side do you think is bearing the most in her mind as we approach this hearing?
I think the pressure here is to make sure that the state of South Carolina gets it right, whatever way that is. You mentioned some admissibility rulings. Let's not forget, even if Chief Justice Toal finds that Ellick is not entitled to a new trial based upon the allegations of improper jury influence, there's still an appeal pending. So even if there's not a new trial based on this after discovered evidence issue, this case is going to go right back to the Court of Appeals and potentially the Supreme Court to rule on those admissibility issues and to rule on those evidentiary findings that Judge Newman made. So I think she is going to be primarily focused on this after discovered evidence. And I think one of the key issues that she's going to be dealing with is when exactly this evidence was discovered. The jurors were polled following their verdict. They all said that it was their verdict and that it was still their verdict. They were instructed during the trial by Judge Newman to only consider the evidence presented to them during the course of the trial. Presumably, when they answered, "This is my verdict, this is still my verdict," they're affirming that they were basing it only on the information provided to them during the course of the trial. All of the cases that are referenced, that are cited in the briefs, deal with situations where jurors made it known to the trial judge during the course of the trial or during the course of deliberations or immediately thereafter that something improper had potentially occurred. In this case, we're talking about allegations that did not arise until months after the fact. And I think that is going to be a big issue for Chief Justice Toal to tackle, because we certainly have in South Carolina and in the United States the presumption of innocence. We certainly want to make sure that no innocent man goes to jail. There is a paramount importance to giving everyone accused of a crime a fair trial. But there's also a very strong state interest in ensuring that juries, when they render their verdict, that is their final verdict, and that juries should not be forced to come back months or years after the fact and revisit these issues. They were in a laboratory of sorts, a clean, sterile environment for the period of time during the trial. Supposedly, they were supposed to be free from outside influences, outside research, that sort of thing. So the notion that a juror could potentially throw the 7 weeks of work from the trial and the months of work prior to that by both sides out the window because they decided they didn't really like what they said at the time is going to be an issue, I think.
Yeah, the question is, if you had these concerns, why didn't you raise them during the trial? Is that the basic point?
Right, and we even see that in the latest filing this morning from the defense, their pre-trial brief, pre-hearing brief. They reference some of the other court staff, including another clerk of court who was assisting Ms. Hill during the trial.
Rhonda McElveen, I believe her name is, the clerk in,
I think
it's on my coffee cup, Barnwell.
Yeah, okay. and one would think that if court staff or if the other clerk were aware of issues with Ms. Hill's behavior and her interactions with jurors, if they were concerned enough about it to take it to her, that they would also have let the judge know. and if for no other reason than to make sure everybody knows all of the information and let the judge decide how to handle it. And so it's odd to me that we're really finding out about these new accusations today, and the status conference is next week, and the hearing is a couple of weeks from now.
Mm-hmm. And all of this, your basic point is that if these allegations had been brought to the judge the way that they were supposed to have been brought to the judge at the time they were supposed to have been brought to the judge, we could have dealt with this all at that time. And let me ask you this question too, because this is something we spoke with Lauren Taylor in this studio a week or so ago. She'll be back on to talk about some of these rulings, but she made a point off camera that I thought was very interesting about how Judge Newman specifically referenced in the court transcript that he was troubled, that disappointed that the clerk of court had interrogated one of the jurors outside of his presence. And yet no motion was made by the defense at that point for a mistrial. Is this another one of those sort of examples? Well, hey, if all this stuff happened and you knew about it, why didn't you make the point then?
It is. And I want to be careful because, when you're in trial, you have a million things going on in your mind. And so it is really hard to think about every little thing that you might need to do, especially when it comes to error preservation. I've had trials where you actually had another lawyer whose sole job was to sit in the trial and make sure that you preserve the record for an appeal. I mean, that's how important it is sometimes, and that's how hard it is sometimes to make sure you're doing that. But that is, I think, an issue. I don't think that's going to be something that carries the day necessarily, because our courts have said we're not going to basically play a game of gotcha with lawyers. Judges are lawyers. They understand the pressures that exist, and everybody is entitled to some grace. But it is an issue, and it's an issue, I think, when the defense affirmatively stated they were not going to challenge the dismissal of the juror. There is an issue there, but I think their response is going to be, this is something completely different.
Well, let me ask you about that, because we're talking about the standards, the core threshold that the state's going to have, or not the state, that the defense has to reach. In this case, the burden is on the defense, but they're arguing that two things can be true at once. In other words, the verdicts could have been exactly what the jurors believed, and yet tampering could have occurred, and that the only standard they have to reach is that tampering occurred. The state, of course, is arguing that not only does the defense have to prove that Becky Hill tampered, but beyond that, they have to prove that tampering impacted the decision that the jurors ultimately reached. As you look at this back and forth over those competing standards, which one do you think is going to hold the day? Which one do you think Justice Toal is going to look at as, okay, this is the one I'm going with in this case?
I think you've got to look at the ultimate effect that any communication had on the jury. Otherwise, you are really opening up a can of worms to any potential juror coming back after the fact and making an allegation against an official. And if it's supported, then we've got a new trial. Well, the state has an interest in affirming its verdicts, its jury verdicts. And I mean that not only convictions, but acquittals, and also in the civil arena. There is not this desire for courts to continue to revisit the same matters over and over and over again, which is why you have the burdens on the moving party to establish, their proof. So in this case, I believe that the ultimate question is going to be whether there was an effect on the jury.
Really?
Yeah. And one of the things I think is that it's going to, if I was a defense attorney, I would try to tailor my arguments as closely to the State v. Kelly case from around 1988 as I could. That was one of the cases that Chief Justice Toal addressed in her time on the Supreme Court. She was a brand new associate justice at the time, I believe, and she was on the losing side of a 3-2 decision.
Related to jury tampering.
Related to jury tampering. And in that case, one of the jurors, I believe, it was a sequestered jury. It was a death penalty case, which brings in a whole host of other considerations not present here. But it was sequestered jury, death penalty case. One of the jurors had brought in a pamphlet related to religion and capital punishment, something to that effect. In the course of investigating that, it was determined that a few of the jurors had seen it. I think some said, yes, I've seen it. I didn't read it. The juror who brought it in admitted to bringing it in. No one said that it affected their verdict. Then Associate Justice Toal, in the dissent, said that the fact that the pamphlet was in the jury room, the fact that this juror knowingly brought it into the jury room when they were being sequestered, brought it in before the trial started, that those facts led to the only conclusion being that this pamphlet must have permeated the jury room, and that you cannot have a fair trial when that has gone on. So if I'm a defense attorney, I'm trying to craft my arguments in this hearing to show that these communications were not just with a juror who was deliberating. My argument is going to be aimed at this permeated the jury room, and it's evidenced by the affidavit of the deliberating juror, by the egg juror who was dismissed, and also by an alternate. And really focus on that point and let the state try to argue that it was still harmless.
Essentially force the state to argue against Justice Toal's own dissent.
Yeah. And one thing you don't want to do.
Strategy there, my friend.
Yeah. One thing you don't want to do is argue against Chief Justice Toal, because she's probably going to beat you.
That is one thing that everybody looking at this case from all sides has argued, that nobody in that courtroom is going to know the law better than the Chief Justice. Obviously, she'll be a former Chief Justice, and that obviously she'll be very well versed in the precedent, particularly opinions that she's authored or signed on to. Let me ask you this, though. You mentioned that prior case, and we've heard about that case. We've heard about Green with the bailiff making the offhanded comment during the deliberations after the evidence had been presented. But let me ask you this. Precedent obviously matters, but is it safe to say and fair to say that in South Carolina, we do not have any case that matches these circumstances that we're facing now? A clerk of court, the top administrative official in the trial, accused of improperly influencing the jury, in fact, accused of engaging in a conspiracy to kick a juror off. We haven't seen anything like this. There's no precedent that specifically applies to this case, is there?
No, there's not. And I think that's why has been so much discussion about what might happen, and why there's so much uncertainty about how even this hearing is going to take place. We've got a number of issues that are going to be before the court for the first time. And frankly, I think that Chief Justice Toal could reach a conclusion either way based on what she believes is correct.
Bill, let me ask you this. Based on that lack of precedent, Justice Toal has a wide range of latitude in this case, doesn't she? It's almost like we talked about those external factors. She can move this one way or the other. Would you agree?
She can. I think I suspect, though, that she is going to have in her mind, and we may find out this as early as next week, she's going to have in her mind the one or two key issues that have to be decided, the dispositive issues in this matter, and she is going, I believe, to tell the lawyers, we're going to focus on A and B. You can leave X, Y, and Z at the door. We're not going to talk about it. It doesn't have anything to do with this. And we're going to focus on what I need to know to make my decision. And so I think in that regard, you're going to see potentially a very refined and discreet hearing.
Mm-hmm. Now, both of these lead attorneys, Dick Harpootlian for Alec Murdaugh and Creighton Waters, the lead prosecutor for the state of South Carolina, both have very publicly expressed their respect for Justice Toal, their affinity for her. Creighton Waters was on Twitter the other day with a picture at a recent investiture ceremony for another judge, praising her. And of course, Dick Harpootlian had dropped Justice Toal's name publicly at several points along the way during this process. So obviously both sides have clearly placed their faith in her credibility here, her ability to impartially hear this matter. As you look at Justice Toal's potential ruling in this case, let me ask you this question. Do you think she will issue a ruling from the bench at the conclusion of this evidentiary hearing in late January? Do you think she'll take her time with this decision? Obviously, we're talking about a ton of complicated issues. Let me ask you this. What do you see her doing, and how long do you think it will take for that process to unfold once this hearing is complete?
If she denies a new trial, I think she could do that from the bench. I think if she grants a new trial, I think we're probably going to see an order that details the findings.
So if we have a quick news is bad news for Alec Murdaugh.
I would think so.
If she says from the bench she's taking under advisement, that could be good news for Alec Murdaugh.
It could be. But this is, 1,000% speculation on my part, because this is all, it's all new, and what we don't even know what evidence she's going to take, and what she's going to have to digest at the trial in order to make her decision.
And a lot of that will be conducted behind closed doors. Obviously, we were talking about that motion, or rather the pretrial or pre-hearing brief. All these terms are so many motions here, but the filing from the defense this morning focused on who they intend to call, and there were 5 individuals listed. There were the 3 jurors, one, the egg juror that was booted, and then Rhonda McElveen, the clerk from Barnwell, who helped Becky Hill during the trial. Those were the 5 they indicated they were going to call for sure. But the defense also had a list of potential witnesses that they could call based on what Becky Hill may do or not do at this proceeding. That included her son, who has been criminally indicted for wiretapping, ostensibly in connection with an investigation of the jury tampering allegations. Let me ask you this. The folks that are on that list that you saw this morning in the filing from the defense, what tea leaves do you read from those names and those juror numbers that are on that list?
Well, I think the court staff, the fact that the defense may call additional court staff, means that they are going for the clerk's scalp. They see that apparently as their strongest and best argument to a new trial, to completely discredit her and to make it to where Chief Justice Toal is forced to take the word of the juror, juror 630, I believe. But what's interesting about that, and even though I grew up in Walterboro, I don't have any idea who the jurors were. The ones who've been on TV, I didn't recognize. I don't know. So I don't know who juror 630 is. I don't have any clue. It could have been my Little League baseball coach for all I know. And I say that because it's interesting to me that the juror was willing to sign an affidavit for the defense that kind of, sort of gives an inference of improper conduct by the clerk. But according to the most recent filing I've seen from the state, when SLED went to talk to that juror, the juror declined. And, you know, one could surmise that a juror might draw the line at giving false information to a SLED officer, or not wanting to face hard questions from the SLED officer, versus signing an affidavit that is true but is shaded one way or the other. Again, I don't have any idea. That is speculation. But it was notable to me that was one of the jurors who had not talked to SLED. And I think that is something that the judge might also inquire about.
Well, and let me ask you that, because as we think about these jurors are going to have to go in camera, they're going to talk to Justice Toal in chambers, or at least with a closed courtroom. Media won't be there. Hopefully we'll get a transcript of that. But are they allowed to say, I'm not answering these questions? Are they allowed, or do they have to answer her questions regarding the tampering allegations?
So these jurors, I'm not aware of any crime that they would have committed in connection with what has gone on. I don't believe that even the affidavits executed would be considered perjury, even if it's found to be, you know, not completely accurate or somewhat. I said shaded earlier, and I'll use that term again. Somewhat shaded truth, you know. So that would be the only reason why they would not be able to answer a question. Presumably, they're going to be under subpoena. You know, now they won't have to answer questions, and they likely will not be asked questions about conversations they've had with their attorneys. Those would be privileged, and of course, that would be off limits. But by and large, they're going to have to answer the questions that the judge asks, I think. And you know, that's one of the reasons why this is going to be done in camera, because the jurors have a right to be as comfortable as they can be in these circumstances. We already have a hard enough time finding jurors for trials, and you know, this is going to make it even harder, I fear.
Well, it sounds like several of them want to talk. Sounds like several of them are more than comfortable sharing their perspectives based on the affidavits we've seen. But also, if you look at, you know, I think the state had a spreadsheet of the juror numbers in one of their earlier motions in response to the tampering allegations, in which there were a few who just weren't talking to anybody at that point. And so I guess my question was, do they have the right to continue not to talk throughout this proceeding, or could they be compelled to answer questions about what they know and what they don't know? But I think you answered that well. But let me ask you, speaking of answering questions, this is a question I asked Lauren Taylor when she was in here the other day, and I wanted to ask you this as well. If you were advising Becky Hill ahead of this proceeding, would you instruct her or advise her to assert her Fifth Amendment rights not to testify, or would you advise her to testify? Because she will not be in camera. She would be in open court. And as we have seen over the last few months, there's been a boatload of bad news for Becky Hill. Her credibility as a fact witness in this proceeding is pretty much shot to hell at this point. What would you advise her to do if you're her attorney?
I think she's got to get up there and tell the truth. I think she's got to be forthright with the court. That is the clearest way through. It may ultimately not be the best thing for her individually, whether, you know, as the clerk of court or other matters. But that's going to be the way that everyone can feel comfortable, I think, with knowing what actually occurred and what did not. So, not having all of the information, not knowing everything, and certainly who knows what else is going to come out in the next few weeks. But I think the best thing that she could do would be to get on the stand and tell the truth.
That is exactly what Lauren said that she would advise her to do. Let me ask you this, though. Assuming Becky Hill doesn't go that route, assuming she decides to invoke the Fifth Amendment, how does that play out? How does that impact this decision?
So, ordinarily, let's talk about this in a broader point first, and then we'll come back. So, ordinarily, in a criminal trial, of course, the defendant has the right to not testify. The jury is instructed not to take a negative or positive inference from that. Okay? In a civil trial, you do not get that same benefit of the doubt. So in a civil trial, if someone gets on the stand and pleads the fifth on a question or two or however many, the judge will instruct the jury that they can take an adverse inference to that. In other words, that if the person had answered the question truthfully, that it would have been negative to them and that it likely would have implicated them in some sort of criminal matter. What we're talking about here is not a mix of those, because we're still in a criminal proceeding, but we don't have a jury. We've got Chief Justice Toal, who is likely going to take all of the information provided. There were matters raised in the defense memo this morning saying they would object to certain questions being asked. I foresee both sides making objections and Chief Justice Toal overruling them all. She's going to take the information, and then she can decide what she wants to use or not. So in the instance of if the clerk gets on the stand, if she's called to testify and she takes the fifth, I think the natural inclination that Chief Justice Toal would have from that is she was going to draw a negative inference from it, as would most people, I believe.
So as we think about Chief Justice Toal and potentially limiting Becky Hill's testimony, though, is there any world in which she allows Becky Hill to invoke the Fifth Amendment in response to certain questions, yet affirmatively deny her jury tampering in other questions? I mean, doesn't that erode the defense's ability to impeach her credibility?
Well, I think that the fact that Ms. Hill submitted the affidavit to rebut what was said about her by other people, I don't believe that's going to constitute a waiver of her Fifth Amendment rights when it comes to testifying. If she's subpoenaed, which we all assume she will be, and called to testify, at that point she will have to decide whether she is going to answer questions or invoke her Fifth Amendment. If she starts answering questions, I think she's going to be compelled to continue answering questions.
What's the remedy if she doesn't?
She would likely be held in contempt of court.
And could they strike the entire testimony if she selectively invoked the Fifth? So
they could do that. The court could order her to answer the questions. There is a potential coercive effect of contempt, which is, you see this a lot of times with media, where they might refuse to divulge sources, and the media member is placed in jail until they agree to provide the source. That could potentially be a method. I'm not suggesting that it's going to be, but that is in the quiver of remedies available. In all likelihood, if the clerk started answering questions and then refused to answer others after being instructed multiple times by the Chief Justice to answer the questions, Chief Justice would probably simply strike her testimony.
And in that event, the state's got a tough road to hoe.
They do, but they could still potentially argue that the comments that were made, because again, the testimony or the affidavits we have relate to body language. I believe the likely most damaging potential statement is the suggestion that the clerk told jurors not to be misled by the defense. That's a whole nother level. But if the statements in the testimony is that she was telling the jurors to watch body language, watch how they respond, that sort of thing.
She could have said those about other.
She could have said it every day of the trial.
Yeah,
and then you're in a situation where you're overstepping your bounds there, Madam Clerk, as far as what your job is, but you're not impacting a decision because it's a consistent issue. So that could be proven by other jurors who are called. And I think it's sort of interesting that the defense wants to short circuit any of that by saying that the jurors who were not present for the alleged statements have no relevant testimony. I think they do. I think if their testimony would be that the clerk was making these statements on a regular basis, or even, at the beginning of every week, as you hear the witnesses this week, watch their body language, that sort of thing. The relevance there is that she was saying that all the time. It wasn't special emphasis on when Ellick was testifying.
You used that word permeated earlier. If the defense wants to invoke it in one sense, it would then conceivably could be argued you've got to allow those other jurors to share their thoughts on whether or not they believed, it was a one-time thing or whether or not this was something that the clerk did for all the witnesses.
That's right. And I think that the judge, Chief Justice Toal, is going to err on the side of caution as far as who she hears from. I think she's going to want to hear from all the jurors, so that she knows what they saw or didn't see, and so that her questions can be answered. Because ultimately, whoever prevails on this is going to be who has the questions answered to Chief Justice's satisfaction.
She's got a ton of discretion in this.
She does, but I would not want to be in her shoes right now.
Yeah, either way. Well, Bill, this is a case that, again, was confounding when we went through it the first time. This process of the retrial hearing has been even more confounding. I can't even imagine a second trial if that is indeed what it comes to. But I want to thank you for not only taking the time on the show, but I also want to thank you. You are always, as I mentioned at the outset, somebody that we rely on to keep us honest as we report on this stuff. And so I am grateful for the fact, there are a lot of folks in this business that somebody offers some criticism, they'll block them, they'll mute them, they'll get mad at them. But I'm actually grateful for it because it helps us do our job better. And so I'm grateful, and I hope you will continue to perform that function, and hope you'll come back on as this process moves forward and share more of your insights with our audience. Absolutely, and I appreciate that, and I'm gonna work hard to also commend you when you get things right. Those are rare occasions. But anyway, Bill Young, thank you for taking the time to be here. Thank you for your insight on this. Just an amazing case, and hope to have you back on it soon. Thanks, Will. See you soon.